Your Honor, I think what's happening here is we had a sidebar to avoid a proper assertion. I said I'll do it a different way. And so I came back here, and instead of telling Mr. Jones that he had lied, I said if one did, that would cause damage.
Who cares?
Well, I think, so I think it's got to be asked in a way that, and I don't want to tell you how to ask it, but
Your Honor, this is.
no, let me just
I'm sorry.
get it out. Where we're not putting Mr. Jones in a pickle, but where the jury understands that the issue has been decided, which they've been told many, many times now. So can you think of a way to do it along those lines? So here, the court has already determined that liability is not an issue. The jury is just determining damages. And so what's the question for Mr. Jones?
No, there is no, first of all, he's a defendant. This isn't impeachment on credibility grounds.
What the question is, though.
The question is, rather than ask him directly, where he now thinks, a truthful answer would somehow incriminate himself, I've asked him whether or not one would expect that if one were to do these things, it would cause harm. Now, Attorney Pattis is still free to argue at any point that the harm caused here wasn't what the plaintiffs alleged. That's what he's apparently claiming. But Mr. Jones's response to that question, if the answer is yes, one would expect that type of harm, that doesn't violate the court's orders, and it's not false. If the answer is no, one wouldn't expect that. That doesn't violate the court's orders, and it's not false, right? So either one, he can testify truthfully without violating the court's order and putting himself in contempt.
Or I don't know.
Or I don't know.
All right, so
The
how
problem
does...
with that, Judge, is it's argumentative in tone. He's not an expert, and so what one does isn't what we're here to show. We're here to show what he did.
Right, but
And
that's
the
a different,
purpose is being
no,
offered to
Attorney
get into
Pattis,
the state of
Attorney
mind.
Pattis, how many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So, your objection was that it was a motion in limine issue, I thought, that it would require him to lie. I now hear that it's a different objection, that it's speculative, he's not an expert.
I'm waiting to finish, so I don't want to follow your order. I have been an officer for a long time, as you know, I insist on making my record, so thank you, and I'm sorry that I stepped on your question. I thought I wasn't done. What I was trying to say was the following. I objected because he's trying to get an evocation in the jury's presence, which is entirely wrong, without permission of the court. I objected further because he was asking Mr. Jones a question that places him on the horns of the dilemma. In the course of all of his proffer outside the jury's presence, he's now switched it to one would expect. That is simply not relevant. That's argumentative. He's a fact witness. His state of mind about his conduct is...
I can't disagree with that, so I will sustain the objection, and where does that leave us with respect to possible future invocation?
If there's going to be an invocation, I've requested it be, that the prelude to it be outside the jury's presence so that I can argue about whether the plaintiffs are entitled.
All right, so how does that work procedurally? So there's a question, you're gonna invoke on his behalf?
I can't do that, I don't think. It's certainly in the jury's presence. I'll argue, I'll simply say
in a
motion
civil
about
case.
evocation. Motion about evocation.
Okay, does that work, Attorney Matty?
Sure, that's fine.